Yes, hello, my beautiful friends. We are back in business, baby. It's great to see everybody. Happy Friday. Hopefully, your week was outstanding and everything is coming to a nice, easy close and you're ready to set sail into the weekend. You can see we've got a change of scenery here. Your boy is in Anaheim, California. We just were at the Tucker Carlson event last night. I posted a video on this yesterday before we were hopping on the airplane, and it was a last minute invitation. I'm going to tell you all about it, but it was an amazing night. So the video I shared yesterday, we were attending for Tucker and Vivek, right? Tucker and Vivek were there, and it was a great conversation, no doubt about it, but they also had a special guest that they announced, and the special guest who came out was the one and only RFK Jr., baby. And so RFK Jr. came out. He was there last night. So the scene was Tucker Carlson, Vivek Ramaswamy, and RFK Jr. all on the stage. Tucker came out, gave a great interview with the both of them. They talked a lot about free speech and about how we as Americans can, yes, of course, deal with our totalitarian government that's putting their boot on our neck on a regular basis. They're part of the problem, no doubt about it. But something that we can do as Americans and as good citizens is to continue to exercise our free speech and to get out there, be vocal about what we're doing, about what we care about, and about our country. And so it was very inspirational. It was a ton of fun. And so we're going to do a full debrief on it. I had a bunch of videos I was recording all night long. And so we're going to assemble those into a nice little highlight reel. And so we'll be talking about that later on. But I did want to just share with you. So Tucker has posted already the actual event. So Tucker is posting these things out there. He posted the full hour, 39 minutes. You can see this is kind of what the scene looked like. They brought RFK out. I got to meet and shake hands with all three of these gentlemen because your boy was fortunate enough to go backstage, courtesy of our friend Joe Polish, who I'll tell you a little bit more about here in a second. But it was amazing. Our seats were, so this was the stage. Our seats were literally, I was front row just to Tucker's right. All right. So I could have, if I really wanted to, I could have spit on him probably if it was a good one. But I didn't because I like Tucker so much. But it was amazing. So I was right there and got to meet all these gentlemen, got to shake their hands. We got some photographs and it was just an awesome, awesome experience. And the reason why we missed the show yesterday is because we had this once in a lifetime opportunity. I got a phone call from my friend Joe Polish. Joe Polish, I've talked a lot about here on this channel and the Genius Network. And he gave me a call. We were on a meeting yesterday. He said, hey, you want to hop on a plane and come join me out here? And so we kind of dropped everything, hopped on, and it was just a heck of an experience. And so if you're not familiar with Joe Polish is just the man. He's the founder, the creator of the Genius Network. I'm a member, been a member for a long time, and I highly recommend it. So this is just their website. If you want to check it out, check out geniusnetwork.com, and you can follow Joe Polish. He's also over on X, and he's doing some great stuff. And he wrote this book called What's in It for Them. We did an interview on this channel with him a long time ago. And so I want to thank Joe for making it all possible, for allowing us to join him on the fun, because it was just a heck of a night. And so check out Genius Network if you're interested in it. It's a great mastermind group, a lot of very, very influential, amazing people in the group. And arguably this show wouldn't be what it is without the Genius Network. So shout out to Joe Polish. We're grateful for our ability to be here and attend the event. Now, my friends, there are a lot of things that we're going to talk about today. We've got some stuff that is fresh out of the oven. So let me give you just a quick rundown and a breakdown of what we're going to talk about today before we actually get into it. So you saw fresh out of the oven was Judge Mercan. Judge Mercan has issued a new order, a new sentencing, a postponement order. And so we're going to read through this full thing. The left has got to be furious about this because sentencing was supposed to be happening on the 18th, very soon. Now it's not going to happen until after the election. And so we'll read through that filing. We'll read through this one. Another good one from Todd Blanche's team. Trump's defense team is saying that they also, remember, we're trying to remove this case from the state court into the federal court. And now that's kind of going to be, well, they're still going to try to do that, no doubt about it. But the real end game was to just delay this past the election because it's a rigged prosecution. And looks like that has been accomplished. So we're going to go through that. We're going to break down exactly what happened on the New York conviction case, as they call it, and what happened there. Then we're going to jump over to January 6th because we've got this tweet thread from Roger Parloff. We've covered him many times. You know, he does great X threads, and he put together a great one on everything that happened yesterday in Washington, D.C., the D.C. Circuit Court, because what's happening here is Judge Chutkan is giving Jack Smith a nice little gift. And so we're going to explain what this gift is. You can see it's right there in paragraph 3, but we're going to come back to that. We'll read through it. We'll see what it means. We'll go through the hearings because now that the New York case is going in the garbage, we're going to ask ourselves, what are the Democrats and the Department of Justice, what are they going to do in response to this? So we'll go through all of that. And then we're going to wrap up the day, my friends, because this morning there were oral arguments in the E. Jean Carroll case. E. Jean Carroll, of course, was the Bergdorf woman who got Bergdorfed in the dressing room at Bergdorf's. And we think, in our opinion, she's just a crazy person, right? She was painting her trees blue and she's named her cats like vagina and stuff like that. Very strange woman, all sorts of weird fantasies and just out there. New York created the law so that she could file a claim. She filed the claim. Trump lost that, even though the jury found, in my opinion, that she was a liar, right? She said that she got R'd in the dressing room. No, they just said it was a grab him by the Bergdorf. It was just the old DJ Diddles type of situation. So that's all it was. Now we're going to listen to the oral arguments here. They're pretty short. It's about 22 minutes, I believe. Each side gets about 10 minutes. And so we'll go through that. And then Donald Trump is reacting to this because evidently he was there. And so we're going to listen to him talk about this. And this clip, I got to tell you, made me nervous as hell as a lawyer. I'm like, Alina Abba, what are you doing? Get in there. Stop him. But Trump knows where this is going, right? This is my lawyer versus my MAGA spirit. Okay. MAGA spirit wants to go one way. Attorney liability concerns want to pull you the other way. So we'll talk about that all coming up. It's going to be a great stream, my friends. So sorry that I missed you yesterday, but as I said, the trip was just wild. And so we got back here late, about 11 o'clock, which is like way past my bedtime, but it was so worth it. We had so much fun and I got some great stories to share. So we'll come back on all of that. We got some business to attend to today. Before we get into the business of the day, let's make sure that we are properly prepared for whatever's coming next, courtesy of our friends over at the Wellness Company. And so we have our friends at the Wellness Company that help us get prepared for all the stuff that is coming, and including a lot of stuff. We've got bad news all over the place. And in fact, what we're going to see is that it's not just a coincidence, right? The World Health Organization is talking about monkeypox. They're setting us up for a bird flu summit. We've got debates, and these things are not just coincidences, right? These are calculated moves that are designed to exploit our fear and keep us under their control. And we know that last pandemic, 48% of Americans didn't have their emergency supplies ready. And according to the National Center for Disaster Preparedness, this was a problem. We saw pharmaceutical industries. They failed us last time, and so now it's time to take control. And you can get your Wellness Company Contagion Emergency Kit. It's packed with all sorts of good stuff: hydroxychloroquine, Z-Pak, Tamiflu, budesonide. You don't have to wait in line. You don't have to freak out about it. You just save a few clicks, go to the Wellness Company. It'll get delivered right to your door. And so you don't have to let yourself get caught off guard again. Act now. Protect your family before the next pandemic comes around. Let's be proactive. Let's be prepared. Order your Contagion Emergency Kit today. The link is in the description below, twc.health/Robert. To grab it, your Contagion Emergency Kit, promo code Robert. At checkout, you're going to save $30. So check it out, twc.com, twc.health/Robert. And you can use code Robert. And remember, these kits are limited and they're only available in the United States. And so thanks to our friends over at the Wellness Company for being sponsors here and allowing us to do what we do. All right. So now, without any further ado, let's get into this one because we've got some fresh stuff out of the oven. Judge Merchan and Alvin Bragg are now losing their last desperate effort to get Trump sentenced before the election. And this is fresh out of the oven from New York courts. You can see Merchan is now going to be caving. They wanted Trump sentenced. They're not going to get it done in time. And here is what the judge wrote to everybody, including Todd Blanche, which is Trump's defense attorney, and Matthew Colangelo, which is the government prosecutor who came from the DOJ, from Biden's office, to go and specifically help Alvin Bragg, who's incompetent, to create some sort of a rigged prosecution against Trump. Remember, this is former Biden, number 3 DOJ, one of the highest positions in there. He left that office to go prosecute Trump. This amazing opinion is coming out on September 6th from Juan Merchan, acting judge. He says, all right, dear counsel, both sides, by letter dated August 14th, so Trump sent a letter. They say Trump requested an adjournment of the sentencing, which is what was a postponement. Just, we don't want to have it happen now because, well, a lot of reasons. One is immunity. The entire case should be, no, thank you. No, thank you. 2 p.m. Thank you. Okay, that's housekeeping. We got a late checkout so we could do a live stream. And apparently they didn't get the memo. So we're back. So Trump says defendant requests an adjournment of his sentencing, currently scheduled for September 18th, 2024. And until after the 2024 election. But there's another reason, okay? It's not just about the election. It's because there's about immunity. There's a bunch of immunity that immune evidence that was brought into the trial. Remember, they talked about Madeleine Westerhout, the White House Oval Office coordinator. We had the comms director, Hope Hicks, all immune stuff that should have never come into the trial that they need to settle, which is why sentencing shouldn't happen right now. He argues that adjournment is necessary to provide adequate time, says Trump, to assess and pursue the appellate options in the event this court denies his motion to avoid the impact that a public sentencing could have on him and his prospects in the upcoming election. So we see Merchan is framing this just from the beginning about election stuff. Now, he attempts to bolster his application. This judge is such a, I'll just be nice. He attempts to bolster his application by repeating a litany of perceived, this he's talking about Trump, and unsubstantiated grievances from previous filings that do not merit this court's attention and will not be addressed in this decision. Now, the people, Alvin Bragg, the people that the judge loves, they state that they defer to the court on the appropriate post-trial schedule. And when we saw this, when we read this the first time around, we were calling Alvin Bragg pathetic and spineless and weak and a coward because they're going to defer to the court on the schedule. These were the same people that said we have to have this trial now. They were going so fast that they actually, remember, replaced the January 6th case with this case. They accelerated it because Judge Chutkan did the right thing and actually paused the case while the immunity was pending with the Supreme Court. So that did not happen here. So then they when all of the other 3 cases failed in Fannyland, in Florida, and when DC was up on appeal, then they accelerated this. They put this trial back in place because of the urgency. So then now when push comes to shove, the government prosecutors suddenly defer to the court after screaming at us that Trump stole the 2016 election because he mislabeled or something, fraudulently labeled payments to his attorney. They're going to defer to the court now? Okay. But nonetheless, the people, Bragg, the prosecutors, to assist the court with its determination, identify several reasons why an adjournment would be appropriate. Huh. Well, that's very curious, Judge. Why is this as a postponement suddenly now appropriate? Let's see. Now, on August 29th, Trump informed this court by letter that he'd filed a second removal notice, which we read, with the Southern District of New York. In the motion, it was denied by Judge Hellerstein, like immediately, like within hours. Remember that? And defendant is currently appealing the decision to the Second Circuit Court of Appeals, where Trump was today dealing with another appeal on another rigged case called the E. Jean Carroll case. He was there for oral arguments in the Second Circuit. So the judge, Merchan, he writes from New York. He says, as a threshold matter, this court finds that despite the prosecutor's stated neutrality, as they claim, they present concerns in their letter of August 16th. Yeah. In a manner which seemingly supports Trump. Ah, that's great. Because that's exactly what we said. We're like, okay, they're just being weak here. They know that the Supreme Court shredded what they did here because what they did was unconstitutional. And their case wasn't appealed at the Supreme Court, but they were doing the things that the Supreme Court said they shouldn't be doing. Or they should have handled it differently like Judge Chutkan did, but they didn't. So the prosecutors know that. Bragg knows that. Colangelo knows that. So they can't oversell it. So they're like, well, we think we want this done quickly, expeditiously. Like there's no reason for delay. We're ready. But the judge knows, no, that's not right. The people certainly do not oppose, and a careful reading of their response can fairly be construed as a joinder of the motion. Oh, wow. So this judge is interpreting the government as basically agreeing, like a joinder, is kind of agreeing with Trump. They're not opposing it. They're not really they didn't say in the motion, like, we oppose Trump. And this is how it normally works, right? Let's say, for example, you get charged with a DUI or something. You've got a trial coming up. An attorney needs a postponement because of a family emergency, right? People will have a conversation about it, and you will say, I do not object. Prosecutor needs a continuance. I do not object. Or the defense needs a continuance. I do not. Or you do object. You say, no, I don't care. Family emergency, that's too bad. It's not violating my client's rights. Trial's on scheduled, so see you there, or don't, or whatever, right? Cops maybe have an emergency or whatever. They're not available as witnesses. We fight over that all the time. But you have a do not oppose. You can also have a no position, right? So, which is kind of similar, but it's like, we're a little bit more neutral. Like we take no position on this, or we do not oppose, right? Which sounds a little bit more like, okay, we kind of agree with it. So they certainly do not oppose it because they didn't say we object, clearly. But they kind of agreed with Trump, didn't they? That's why this judge is considering it as a joinder. Oh, man, I wonder how Alvin Bragg is feeling today. Matthew Colangelo, they're having a bad Friday morning. Now, notably, had Trump been sentenced on July 11th, as they originally scheduled, there would, of course, have been no cause for the delay, says the judge. However, on July 1st, the Supreme Court of the United States rendered a historic and intervening decision in the immunity case. That's nice that this judge recognizes it is intervening. He could have paused this case like Judge Chutkan did. She did the right thing on it. For whatever we say about Judge Chutkan, we say a lot, she did the right thing on it. She actually paused the case. She did not want to. We had to drag her across the line, kicking and screaming to do it, but she did it. This judge did not, and he just kept the train moving forward. Now, relying on that decision, Trump immediately sought leave of this court to file a New York motion to set aside the verdict, right? Supreme Court says there is, in fact, immunity. We have three buckets. We have stuff that is absolutely immune. If it's official presidential duty, you can't be prosecuted for doing your job. You're immune. If it's within the outer perimeter of the presidential responsibilities, then we say there's a presumption of immunity because we don't want to impede on the traditions of the executive branch. And if we then have conduct that is not in either of those buckets, it's clearly outside the scope of the presidency, then that is not immune. So we have three buckets. Now here, Trump said, well, you guys introduced evidence that was in that first bucket. You talked about Oval Office comms. You talked about White House communications director and Oval Office, sort of like chief of something person, which was Madeleine Westerhout. So on the instant matter, they say, Trump says, well, if you introduced evidence that's in that first bucket, you cannot do that. So this case needs to be set aside. You cannot, obviously, you shouldn't have done that. Supreme Court said you shouldn't have done that. And you should dismiss this indictment. Now, in light of the Supreme Court's decision, writes Judge Mercan, which this court must interpret and apply, the court granted Trump leave to file his motion. So then Trump tried to adjourn sentencing, right? So the court said, okay, well, let's talk about immunity. And then they said, well, if we're going to be talking about immunity, we have to move the sentencing date, which is on the 18th, until after resolution of his motion was not opposed by the people in their letter. So to allow full briefing by both parties and this court the time necessary to adequately consider the motion, sentencing was rescheduled initially to September 6th. That's today. right? They want to get this thing done. So it was already scheduled for July 11th. We're way past that. Then it was scheduled for September 6th. We're past that. It was then adjourned again to September 18th, coming up soon, following the filing of a third defense motion for this court's recusal, because this court is biased. This judge donated twice to Joe Biden, talked to his daughter about Trump's tweets, how he does not like those tweets when he was the president. So he's got a bias there. And the daughter, who is a very close connection to the judge since he's, her father, she was getting a ton of money working for authentic campaigns, making funds off solicitations off this case, right? Soliciting money, donate to this so we can beat Trump, donate to Adam Schiff so we can beat Trump, and so on. Now, this now means that any adjournment of even 1 week beyond September 18th will bring us approximately 41 days within the presidential election. He goes, oh man, so even if we put it to like September 25th or something, like we're in big trouble, because then it's 41 days. So this matter is one that stands alone in a unique place in this nation's history. It does. What? It does. This judge was telling us, so was Judge Chutkan for a long time, that they don't care about the election. They don't care about the president. They don't care about any of this. Trump is a criminal, and they're going to treat him like every other standard common criminal, except the ones they try to bail out after they burn down the 3rd Precinct Police Department in Minneapolis. They don't really care about them. But they're going to treat Trump like every other common criminal. They said that repeatedly. A unique place in this nation's history. Is that why you gagged him? So that he couldn't talk to us about any of this? You gagged him in the middle of this unique place in the nation's history, so we don't have free speech to hear what Trump has to say about any of this? It's weird that you're suddenly talking about that, because those were our arguments. We said this is a unique case. Everyone needs to know about this. We all need to hear about it. Free speech is important. Trump can talk to us about it if he wants to. It's political speech. It's free speech. It is an election cycle. And they said, no, he's gagged. We don't care about any of that. This is about the orderly administration of justice. Remember, they said that over and over and over again. And we have to make sure our staff is safe and all that crap, which is all nonsense, because they already have law enforcement that already prosecutes people when there are criminal acts of harassment, threats, or violence. And so now suddenly he's going to reverse himself. We're in a unique place in this nation's history, and this court has presided over it since its disgusting, illegitimate inception, from arraignment to jury verdict and a plenitude of motions and other matters in between. Mercan writes, were this court to decide, after careful consideration of the Supreme Court's decision in Trump, that this case should proceed, so it's a question, it will be faced with one of the most critical and difficult decisions a trial court judge faces: the sentencing of a defendant found guilty of crimes by a unanimous jury of his peers, which you just throw that sentence right in the garbage, right? This trial was rigged. There was no unanimous jury also, by the way. Remember, they had to indict Trump or convict Trump, find a verdict against Trump. He has not been convicted yet because the sentencing has not happened. But they needed to find against him on the basis of an other crimes element. And within that element, it was intent to commit another crime. What other crime? Doesn't matter. Didn't have to be unanimous. They could pick any other crime they wanted. So this is a lie. It's just a flat out lie. There were other elements there. And yeah, they needed to be unanimous on that, but it was Trump had the intent to commit another crime. Well, what other crime? Shouldn't that other crime have elements to it? Or the jury should at least be unanimous on what that other crime is? No, the judge said no. As long as there was intent to commit some other crime, that was enough. That's all the statute said. So this adjournment request, and they could pick whatever they wanted. They could have picked a federal crime. Just pick a card, any card. They could have picked a federal crime. They would have won. They could have picked a state level crime. They would have won. They could have picked another state regulatory crime. They would have won. And maybe they did. It was rigged. So this adjournment request has now been decided in the same way this court has decided every other issue that has arisen since the origination of this case. Wow, this is pathetic. Applying the facts and the law after carefully considering the issues and respective arguments of the parties to ensure the integrity of the proceeding is protected, justice is served, and the independence of this judiciary is kept firmly intact. This judge just masturbated right on this page, right in front of us. I'm sorry to say that. Wow. He just masturbated right all over us in this paragraph. Can you believe he did that to us right now? He's enjoying himself. Listen, he says the adjournment has been decided the same way that this has happened every other time. I apply the facts and the law after I carefully considered the issues and respective arguments of the parties, like he's doing a great job, to ensure the integrity of the proceeding is protected and justice is served. And independence is kept firmly intact. This was the most self-enjoying paragraph I think that we've ever read on this channel. This is wild. No judges don't talk like this, right? Why do you have to support yourself? Why do you have to vouch for yourself? This is called vouching, right? You're vouching. You're saying, I'm amazing. I handle this like a perfect pro all the time. It's pathetic. It's pathetic. And he just did that to all of us. I can't believe it. Now, if defendant's motion is denied, if Trump's motion is denied, the law requires the imposition of sentence following a guilty verdict without unreasonable delay, right? So Trump is now going to be challenging this on immunity. And if that comes back and it's denied, then we'll go to sentencing. They say the public's confidence in the integrity of our judicial system, which has been evaporated by cases like this and judges like this, demands a sentencing hearing that is entirely focused on the verdict of the jury and weighing of the aggravating and mitigating factors, free from distraction or distortion. Now, as we're reading this, we're also trying to tease out any insight. Let's say sentencing does go forward, and I don't think that it will. I think that the immunity decision wrecked their case, and we saw that clearly. And putting Trump in prison would have been way too much to bite off. So he's going to use this as an excuse to get out of it. But as we're reading this, what if he doesn't, right? What if he does try to sentence Trump? Is he giving us any hints here? Is he identifying any aggravation that he's seeing that's going to increase the penalty and might lead to Trump's incarceration? Is he identifying any mitigating factors that might justify him giving Trump probation and not incarcerating him at all? He says the verdict must be respected and addressed in a manner that is not diluted by the enormity of the upcoming presidential election. This is insane from this guy. These guys have no consistency or set of values as far as I can tell, because the enormity, they were saying it was irrelevant. That's why Trump was gagged. The First Amendment is dead to them. They were talking about the orderly administration of justice, external circumstances be damned, and we're going to carry on the train. Likewise, if one is necessary, if one is necessary, hopefully I didn't break the computer, the defendant has the right to a sentencing that respects and protects his constitutional rights. Oh, they must be so mad. Unfortunately, we are now at a place in time that is fraught with complexities, rendering the requirements of a sentencing hearing, should one be necessary, difficult to execute. Okay, that's the second time he said that. Wow. So, yeah, I think sentencing is going bye-bye. Thus, in accordance with certain of the grounds submitted by Trump and the reasons for the adjournment that even Alvin Bragg agreed on, coupled with the unique time frame in which this matter currently finds itself. What are you talking about? A unique time frame? It's the same election. Why was 1 week from now any different than September 18th or July 11th or September 6th? What are you talking about? A unique time frame all of a sudden? This is a red herring. This is a cope. It's not about a unique time frame. It's about the immunity decision. So he's now trying to say, well, we're getting a little close to the election. It's like, bro, you were going to sentence him on the 18th. You set that date. And now you're complaining that if you set it on the 25th, like that's a little too close to the election, but the 18th is not? No. It's a red herring. It's a cope. The decision here and the imposition will be adjourned. So, let's back up. Now the court is in a unique time frame this matter currently finds itself in. The decision on the immunity motion and the imposition of sentence will be adjourned to avoid any appearance, however unwarranted, that the proceeding has been affected by or seeks to affect the presidential election in which Trump is a candidate. This judge is trying to back out of this. Okay, this is a kid who got caught with his hand in the cookie jar. Now he's trying to talk his way out of it. He says, I don't want to be responsible for interfering with the presidential election. I wonder if he got a talking to. I wonder if somebody came and had a conversation with him, because he hasn't cared about the election at all this entire trial. Neither has Judge Chutkan. They've just been moving forward as though it doesn't matter at all. Now, suddenly out of nowhere, it pops out. We're going to adjourn the sentencing because we're too close to the election? That's weird, because for the last 2 years, you didn't care about the election. Now, this court, they say, oh, wow. All right, so here we go. More masturbation. The court is a fair, impartial, and apolitical institution. Adjourning decision on the motion and sentencing, if such is required, should dispel any suggestion that this court will have issued any decision or imposed any sentence to give an advantage to or to create disadvantage for any political party or candidate. Wow. So most of this opinion feels like it's the judge vouching for himself. Like, obviously, this is the right thing to do, but to be honest, the whole case should have been adjourned, right? They brought it to prosecute Trump in the middle of the political season. Now, when it's the big end game, it's like, hey, it's time to, it's really time to do this thing. Like, you've been doing it for 2 years. Are you ready to go? Like, you just climbed the entire ladder. You have to jump. No, I'm not going to jump. What? You came up, like, be brave, right? Dive into the pool. And they're not doing that here. Adjournments for sentencing are routinely granted, often several times. This is more cope in any number of other criminal matters pending in this courthouse, particularly when unopposed from Bragg, for reasons ranging from personal circumstances to scheduling needs of the parties involved. So now this is like writing for the left, okay? Because they're going to have a meltdown. Andrew Weissman and George Conway. Oh gosh, can't wait to see what those knuckleheads have to say. And they're going to be just losing it. And he's saying, well, we do this all the time, so it's okay. And again, now we're going back to routine. So now he's like, Trump's like a regular routine criminal again, I guess. So given the unique facts and circumstances of this case, there is no reason why this defendant should be treated any differently than any other. Oh, that's the punchline of this whole motion. There's no reason Trump should be treated any differently than any others. Okay, well, you prosecuted him in spite of his immunity. You brought in convicted perjurers to testify against him. You didn't allow any evidence to be admitted from Trump's people, including from the FEC expert witness who would have come in and explained how all of these financial transactions work. You didn't allow that to happen. So Trump got gagged. Do you regularly gag criminal defendants? No, you don't. So Trump got singled out this entire case. Now this judge, my friends, this is such a victory, not only because of the postponement, the new date as we're going to get to, but this is a total admission of fault. And this judge is like a child just trying to vouch for themselves, to talk themselves out of their trouble. No, I am a good person, and I don't lie or cheat or steal, and we do our job here, and we honor the justice system and blah, blah. No, you don't, bro. And now you're going to come back out and say that suddenly the election matters. And suddenly now we're going to make sure Trump is accorded the rights of regular criminal defendants. Give me a break. It's transparently false. And it shows us who this judge is inside. He's, I think, a scared person right now. He feels like his legitimacy and his credibility is under attack, because it is, and he brought it upon himself. He deserves every bit of it. This is not a decision that this court makes lightly, but it is the decision which, in this court's view, best advances the interest of justice. So let's see what he says. Therefore, it is hereby ordered that the decision on Trump's immunity motion to set aside the jury verdict and to dismiss the indictment will be handed down off calendar on November 12th after the election. Oh, November 5th, the election, November 12th. Oh no, that is going to be the immunity motion decision. And therefore it's ordered that sentencing on this matter, if necessary, again, is adjourned to November 26th, way after the election. Oh, Andrew Weissman and George Conway and Liz Cheney blown out. Ordered that Trump's motion to preclude the people from filing a pre-sentence memorandum is denied. The people's submission will be filed under seal. And so before sentencing occurs, people create PSRs or pre-sentence reports that, or actually usually probation does that, but sentencing memos, right? Sentencing memos come from the prosecutors and from the defense, and everybody's given the judge their perspective. Defense says probation. Government says 100 years in jail, prison. And the probation says we'll split the middle somewhere. So if the sentencing ultimately happens, then those will become relevant. I don't think that it's going to happen. And this is this judge trying to reverse himself out of this, right? He's put himself in this situation. Now he's backpedaling. And this is great news for Trump, obviously. Okay. Sentencing before the election was an insane prospect. And I think this judge recognized that, right? The pressure is way too hot. They can't sentence Trump to prison. It would be insane if they did that. So he used all of these excuses, which are totally made up. There's a little bit immunity in there, but it's mostly like, well, the prosecutors don't object to it. And the judge is right? The prosecutors don't object. This is the right legal decision, but it's just a small sliver of correctness in a sea of corruption and rigged matters. The judge and he was forced to do this because he can't sentence Trump on the 18th. He knows he can't. And he's trying to cope himself out of the wreckage that he's done to his credibility and his legitimacy. And he's really enjoying himself in this motion. It was a disgusting motion. We're all going to have to take a shower after that. It was the right legal outcome, but it's an admission that just this judge screwed up royally. He doesn't want to say it. He doesn't want to come out and say, yeah, immunity is right. But I think about from the left's perspective on this. They have been invested in this case for years. And now they're so close. They're like 1 week away from getting Trump sentenced to prison. Finally, he's finally going to stop getting away with all this. And they're all going to have a little bit of relief. But no, not now. After all of this, years of prosecution, 4 criminal prosecutions, nothing is going to happen before the election. And that might be by design, right? Part of the process here was to punish Trump. Jack Smith stole $24 million from U.S. taxpayers to use it as a slush fund to prosecute Trump. He has to come out of pocket to defend that. So it's a vicious attack on our country from people who don't care about justice at all. They care about political power and winning. And so we're going to be here to continue to cover this, my friends. Thank you for subscribing and following along wherever it is you're joining us. We'll look forward to seeing you back here on our next segment. And we've got more coming up. So we're going to turn our attention now. We're going to stick with the Trump stuff. We're going to stick with immunity. And we're going to the January 6 case in Washington, D.C. And so let's get into it because we've got a nice X thread here from Roger. Judge Chutkan gives Jack Smith a nice little gift, even though he's not a real prosecutor, completely illegitimate, according to Judge Eileen Cannon in Florida, after that classified documents case got dismissed. But the D.C. Circuit is much different, and they want Trump to be prosecuted, and they want Jack Smith to be able to land body blows, just boom, boom, every time he can. And so we were in court with Roger Parloff in Judge Tanya Chutkan's courtroom, the first proceeding back since this case has come back down from the Supreme Court after the immunity decision was issued. And Roger Parloff was there. He says he's live tweeting this puppy over from Lawfare. We love Roger's work. He does good work. And we reference him regularly, so make sure you're following him. But they say here, the media room has been upgraded. So we're in court. He's in the media room, 2 media rooms, and the screen is on. Now he's bringing us inside the courtroom. And so let's visualize what it's like being in the DC court with Judge Chutkan and the prosecutors. Now, at the moment, we can't see the prosecution table well, but at the defense table, we have John Lauro, shout out for Donald Trump, Todd Blanche, shout out, Emil Bove, and Lauro's partner, probably Gregory Singer. So then the proceeding gets started. All rise. Oh, gosh, here comes Judge Chutkan. Judge Chutkan walks in. Please be seated. Clerk calls the case, criminal case 23-257, United States versus Donald J. Trump. Parties, please. Government prosecutors stand up. Good morning, Your Honor. Thomas Wyndham and Molly Gaston at the table. And we have FBI agent, case agent here, seated at our table, well named, whatever. Defense attorney stands up. Good morning, Your Honor. John Lauro. I'm here along with our crew, and we have a paralegal. And John Lauro has a quip for the judge. He says, yeah, and our paralegal's here, Judge. And I'll have to say to you, Your Honor, it's been some time since we've seen you last, and life has been almost meaningless without seeing you. From John Lauro. Judge Chutkan says, yeah, shut up. Enjoy it while it lasts, she says. So then Chutkan says, listen, I want to begin today by summarizing the Supreme Court ruling that just came down. That's why we're back here. We have a lot to talk about, and we'll do it together to decide what the schedule is for the pretrial proceedings that are going to be coming soon. Chutkan now summarizes the SCOTUS ruling. She says, well, the purpose of this hearing, everybody, good morning, thanks for being here, is to confirm Trump's arraignment, number one. And second, we're going to discuss the trial going forward. Now, I hope to issue a schedule today, and she did, and we'll look at it. But I'm not going to issue it here today. So we're going to talk about it. I'll write it up and drop it out for you when I have that document. Now, Chutkan is saying, let's talk about this superseding indictment, which, remember, was Jack Smith's second draft. He indicted Trump the first time. And in that indictment, as we noted, there was a bunch of official presidential material conduct, stuff that you're allowed to do as the president under the rules of this country. He got indicted for it. Then Jack Smith, that was draft number one. That's your final answer. Turn your homework in. Okay, that's it. Filed that. We had all of these immunity battles, went up to the Supreme Court. The Supreme Court came back down and said, there is immunity. We do actually have three buckets, three different categories of immunity. Jack Smith said, no, we only have one. We have one category of immunity, and it's none. We have no immunity for the president. Zero. Wrong. We actually have a lot of immunity, like a lot for the president. So the Supreme Court said that, and he's sitting here with this crap first draft indictment that is filled with illegal evidence because it's immune. So now she says, let's talk about this. So then Jack Smith filed a second draft. He went through the first draft. He's like, oh, crap, that's bad, deleted. Oh, that's bad, deleted. Oh, that's bad, delete that. And it was a lot. And Roger even created a thread on this that we covered in an earlier show where he's saying, yeah, a lot got deleted. Because Trump's allowed to talk to his vice president. Trump's allowed to talk to the DOJ. Trump's allowed to ensure we have safe, secure, free elections. And we did not in 2020. The CIA was colluding with the Biden administration. Literally, Mike Morrell, ex-CIA director, was a paid contractor with the CIA at the time. He was meeting with Anthony Blinken, who colluded to make the 51 laptop letter that they used in the debate so that they could win. And then Blinken became the Secretary of State. Amazing. So it was rigged. Now, we're talking about the arraignment. Now, Chutkan is describing the indictment, and she says, okay, well, it's a new indictment, so Trump has waived his appearance, and so we're going to accept his plea of not guilty on all four counts for this second draft, second indictment. So confirming all that on the record now. So then Chutkan is now summarizing the four charges, which are the same charges as before. Laura, which is also wild because they missed the 1512 issue. We'll see. So Laura, Trump's defense attorney, confirms, yep, Trump got the indictment, Your Honor. He's seen it. He's reviewed it. We will be entering a plea of not guilty as to all four counts. We'll waive a formal reading of the full indictment. We don't need to read the whole thing. And so Chutkan says, great, I accept the waiver. The arraignment's complete. Trump is now apprised of his new charges. Now let's talk the schedule. Judge says, okay, so let's go over the sentencing scheduling now. She's now listing the pending motions. She's like, wow, we've got a bunch of stuff that's pending because Trump's defense attorney has been filing motions like madmen. Shout out to them. Amazing. And the judge says, well, Trump's reply brief to discovery motions needs to be reset. And remember before, so this is like going, like they went away on vacation for months because everything was literally paused. Like everything was just stopped, paused immediately. When SCOTUS sent the case back, now they're having to pick back up everything. Okay, where we were with this, let's get back on track on everything. She's discussing how much time was remaining on various deadlines at the time of stay. She's talking about motions in limine. Many of those were due in about 3 weeks at the time that everything got paused. We had stuff that was due back then. It's like, okay, where were those? Now she turns to the parties' proposals. So here's like the scope. We've got all this stuff. We got your motions here, motions in limine, 3 weeks out. Here's what I'm seeing. Anyone else seeing anything else? No. Okay, great. So how are we going to deal with all this? Who wants to go first? Well, there's some common grounds. They agree on issues to be resolved. Both sides are there. They're contemplating that at least some issues be resolved concurrently. So we can work on this together with this. We don't have to work. We can work on A and B at the same time. We don't need to do A first and then do B. Government wants other motions decided concurrently. They want A and B to happen at the same time. Like we'll work on this issue and this issue. Wyndham says, yeah, we can do that. So then Chutkan says, well, what do you guys want to do, Trump? Describes the proposed Trump approach, which is probably more sequential. We'll handle this first, we'll do A first, and then B first. It's kind of like if you're eating a dinner plate, right? Some people will eat their steak first, and then they'll go to their mashed potatoes, and then they'll go to their vegetables. Other people will kind of, have a bite of steak, mix it with some mashed potatoes, have some asparagus, whatever, right? Kind of mix it up together. So Trump wants to go one at a time. The other team is just mashing it all into their faces like prosecutors. Now, Wyndham says we're not in a typical situation here. Says SCOTUS, the Supreme Court, this is a government prosecutor, says, let's talk about immunity. I just want to nail down what approach would look like. Now, I've got some questions for the government prosecutor, says the judge. She says, all right, Mr. Prosecutor, so you propose filing before Trump moves to dismiss this case? So you want to file so Trump is going to try to dismiss this based on the Supreme Court immunity decision. And if Trump files the motion to dismiss first, the judge is wondering why. So that's the ordinary course. And then the prosecutor wants to file their brief first. Okay, so who's filing first and how's this going to work? So she says, well, Trump is going to move to dismiss and you want to go first, but that's not the ordinary course here. So why should we depart from this? Why should I allow you to file your brief first and not have you respond to a defense motion to dismiss? Prosecutor says, well, Your Honor, we're not in a typical situation here. Okay. SCOTUS has created new law. We're looking for the most efficient, practical way forward. And so this new indictment that we just have, our second draft, it doesn't include all the categories of info that we believe may be subject to immunity litigation, right? So Jack says, I just deleted all the bad stuff. Our response is, no, you didn't. The whole thing is bad. That's why we propose to go first. So he's like, so we think we did a great job. Like we cleaned it up. It's all great. And so we should go first. Says we should structure a schedule, says the prosecutor, that leads to only one interlocutory appeal. So we don't want Trump, right? If you go, like, for example, if you eat the whole plate at once and you don't like it and you vomit, then everything comes out together. But if you eat one at a time and you vomit, then it comes out by itself. Okay, it's a terrible analogy. I know. Sorry about that. But the point is, they'd rather bundle all the appeals into one. As I said, A and B going together at the same time, they'll appeal both those. Trump says, let's do A. Then if there's a problem with A, we can appeal it, then come back down, then get back on track, then appeal it, then come back down, then do B, then come back down, then do C, and so on and so forth. So they say, well, Trump proposes several interlocutory appeals. Like he wants to appeal this and then this and then this. And so we know there will be an interlocutory appeal. And so we're just trying to limit it to one. So there's not a bunch of appeals going on. So government says we'd file a comprehensive description of both pled and unpled facts so we can tell you what's in the indictment. And we have a bunch of other things, like a bunch of other things that we'll tell you about, like this big fat summary. Chutkan says, well, would that include a proffer? I mean, can you be more specific? Like the form that it would take? Like, what are you talking about? Like you're just gonna like forward me a bunch of emails, or what are you gonna do to show us what your evidence is and how this new indictment is going to be handled in light of immunity? So is it going to include a proffer or what? It says, well, our initial view is this: a comprehensive brief setting forth facts right? In and outside the indictment. Amazing. All right. So substantial number of exhibits, grand jury transcripts, interview transcripts, 302s, FBI interview forms. This would allow the court to continue the context. In addition, we'd set forth why we believe conduct is private in nature and not subject to immunity. Then with respect to allegations about Vice President Pence, which remember is basically the crux of their case now, why we believe presumption of immunity is rebutted. So yeah, Trump has a presumption, but they rebut it. So the benefit of us going first is that you have everything in one place. You have a cleaner docket for you and for any appellate court. It's such a joke about it. Judicial efficiency is certainly a thing, no doubt. But it's the same pattern that we saw with Molly Gaston, the highlighter girl. Remember her? She's like, well, there's 8 million pages of material. And Trump's defense says, well, we need a lot of time to read 8 million pages. And she said, well, no, you don't. Because I highlighted it for you and it's organized, neat. That's not, and Chutkan was like, I love that. Yeah, defense, they highlighted the stuff that you need. So you don't need to read your own evidence because the prosecutors did it for you and they told you what's in there. Oh, so Chutkan says, well, not proffering any actual oral evidence. Okay, so it would be written. He says, that's right. Yeah, we're just going to write a big book report and put it on the public docket so we can just smear Trump outside of a trial without any real cross-examination, just in a big, giant document. We'll just submit it on the record. Since we're not going to get a trial happening before the election, let's just kind of write it in a book report and then we'll just shove it out there so everybody can read it. All the evidence that they would present at trial, they can't, so they'll just write it. So they say, that's right, we're going to put forward a bunch of papers. And judge says, so you said you're prepared to file this promptly? Like, what does that mean? Days or weeks? Well, we do have to write this thing, Your Honor, and that will take a little time, but we've begun already. It's underway. We anticipate we could finish this 2 weeks, 3 weeks, maybe closer to 3. So like the last week of September, you think? Yeah, like September 26-ish, it would be good. Now, the defense has suggested it will take a substantial amount of time for them to put forth their views. This is another reason for us to go first, because we can go promptly. So let us get our disgusting smear dossier onto the docket because we're going first. Judge then asks to speak to Lauro. So what do you think, defense attorneys, about this? They say, well, beyond the fact that the government's proposal is procedurally irregular, is that in and of itself a problem, or is there some other prejudice? The judge asks. Okay, so it's procedurally irregular. So the judge is like, it's just like a, does it matter? Is it a problem that it's procedurally irregular, or is there some other prejudice? Like, is there something else that would hurt Trump like I just described? Defense attorney says, oh, yeah, Your Honor, that's enormously prejudicial to Trump. The government proposes an approach that turns the rules on their heads. They have to look at discovery issues that are outstanding as well. And the judge says, well, why can't you do that at the same time? Like, why can't you do your discovery while you're also briefing this? He said, Your Honor, to address what they submit, we have to have all the discovery. Like, we have to have the discovery first before we can respond to them. So that's why. And everything that we're entitled to. And also, there's another problem, okay? SCOTUS has already decided that the discussions with the vice president were official. So if Jack Smith is trying to rebut that, well, he's trying to rebut the Supreme Court. So as an initial matter, says Trump's defense, the issue before the court is whether the government can overcome that presumption. No way, no possible way that lack of immunity would result in intrusion on an important government function. And so if they can't show that, the entire indictment is improper and illegitimate, Your Honor. It's a gateway issue. It's a threshold matter, and it needs to be decided right now. And the judge says, no, actually, I don't think so. I don't think so. Judge says the Supreme Court ruled on 3 categories. Certainly, vice presidential conversations may be subject to presumptive immunity, that middle category, but I have to decide if those conversations are somehow outside his official duties, says the judge. I get to decide that. Is it presumptive or not? The defense attorney says, sorry, Judge, no, you don't get to decide, right? I don't. This judge is just wild. She's just to be clear what she said, but I have to decide if those conversations are somehow outside his official duties, don't I? Defense says, Your Honor, I ask you to re-review that opinion. Okay, read it again. SCOTUS decided they are presumptively immune. So it's a presumption. So you don't get to decide against that. It's not your decision at this status. Has to see if the government can overcome that presumption of immunity. If in fact communications are immune. So in other words, judge, you have to presume he is immune. You're not looking at this like as a blank slate. Let me decide whether it's immune or not. No, it is immune. Then they present evidence to overcome that, and you decide whether that evidence was sufficient to overcome the immunity that already exists. So I ask you to reread that. Has to see if the government can overcome the presumption. If, in fact, communications are immune, everything fails. The judge says, well, I'm not sure that's my reading of the ruling, says Chutkan, but it's subject to a lot of different readings. It's true. I think that is true. And this is part of the problem, is that Trump will appeal it. Chutkan will say that the whole thing is not immune, right? Jack Smith's second indictment is amazing, and he's a real boy and everything, and he's a legitimate prosecutor and all this stuff. And then Trump will appeal that and say you misapplied the Supreme Court standard. And then the Supreme Court will now have a standard that they'll start measuring against. And we'll get a whole series of case law that will now trickle down from this one decision. So Lauro says, Your Honor, it's a legal decision. We can provide guidance to the court. We don't need a full evidentiary hearing. It's a decision. We'll just give you our argument on it. But we don't need evidence. We don't need to do what the prosecutors wanted to do and create a giant anti-Trump book report that they can just drop on the docket at the end of September. Lauro, defense attorney, says, it's a legal decision. We can provide guidance to the court without a full evidentiary hearing, and we get the opportunity to go first under Rule 12, says the defense. So the rules say we go first. Judge says, well, in one way of looking on it, your motion to dismiss is still pending, actually. And so the government is just seeking a supplemental briefing. Can you believe her? So she's making it up. Well, here, how about this? So I'm going to say that your original motion to dismiss is still pending. And since it's a new indictment, but you already had a motion to dismiss from the first indictment. So I'm going to relate your original motion on the first indictment to this new indictment. And we're going to say that Jack Smith now is not submitting a new briefing because he's already submitted a briefing. So he is actually going second. So we're just going to call it a supplemental briefing now. And the defense, it's just rigged. The defense says, Your Honor, that's ridiculous. They're asking for an asymmetric protocol so that we are biased. Judge says, well, courts rule on time-based, on the time-based on evidentiary proffers. I'm the one to decide, says the judge, and I ultimately need an evidentiary hearing. Are you saying I don't have that power, says the judge? Well, Your Honor, you should scrupulously follow the SCOTUS ruling, is what I'm saying. Well, I don't think they addressed the details of how I do it. Did they? No, they didn't. So you want witnesses? Lauro's defense says, yeah, ultimately we do want witnesses. Yeah, we do. But first we want to resolve the other pending motions. We want to advance our arguments first, right? This is our motion. Judge Chutkan says, well, that's because you don't want to go forward till next year, isn't it? He says, no, that's not why. But she says, that's what your schedule says. Your schedule says you want to go forward next year. So I think that's maybe why you want this to happen. Judge says, look, as I read it, SCOTUS expects us to decide the immunity issue forthwith, as early as possible. And so your schedule, we wouldn't begin briefing immunity until December. Defense says, well, Your Honor, that's because we'd be filing our briefing based on info that we received from the government on these important issues. And remember, Trump was also resurrecting arguments. He was trying to define the scope of the government's prosecution. How extensive was it? Did it, the prosecution team is massive here. It's J6. It's got everybody. So Trump wanted to know who was involved. Was it CIA? Was it Homeland Security investigations? Was it clearly the FBI? Was it DC Metro Police? Was it Capitol Hill Police? Was it other agencies? CISA was involved. Who else was there? So they need to know that. And once they know the scope of that, then they're going to need discovery from all of those people. And you can't have an evidentiary hearing to argue evidence if you don't have the evidence. Now, these should not be decided based on an asymmetric proffer, Your Honor, where they just get to have a full brief and tell you whatever they want. The judge says this is not unfair. Look, it's not unfair at all. The government files an opening brief. You get a look at it. Then you get a chance to address it. There's nothing unfair about any of this. It's just a matter of who goes first. He says, Your Honor, are you nuts? This is incredibly unfair that they get to put this info into the record at this terribly sensitive time. Exactly. They get to write a big fat book report filled with just Trump garbage, anti-Trump garbage. If you're in a trial, okay, a witness comes up, says a bunch of garbage, then you as the defense attorney get to come up and cross-examine that. But you can't do that if they're going to write this big, dossier of anti-Trump stuff. Then Trump responds. We're in the middle of an election. You know how many headlines are going to be coming out of their little book report? A lot. So in our nation's history, says, sensitive time in our nation's history, Lauro says that if the government puts in a proffer, maybe it should be done under seal, right? Now, that's another solution. And if it does, Lauro wants a chance to make public exculpatory material that he says is currently under protective order. Judge says, well, she won't take the election into account in terms of timing, right? Again, this is this judge, which is how Judge Mercan was until he just flipped himself. Well, I don't care about the election. She says, Your Honor, defense, letting the prosecution go first limits our ability to structure our arguments. We've had 14 million pages of documents we've had to look through. Judge says, well, your own proposed schedule says you can resolve discovery issues simultaneously with immunity issues. Well, Lauro says, Your Honor, there's something unseemly about a rush to judgment only in this case. Oh, no, stop it, John. Hardly a rush to judgment. This case has been pending for over a year. We can't even contemplate a trial date yet. Defense says, Your Honor, a new SCOTUS ruling just came down. It changes the entire case completely. Well, we haven't even discussed how long you need to respond to that, John. You can have time to respond, and it's not prejudicial to you at all. He says, it's a quagmire, Your Honor. It's completely prejudicial. We're going to unseal grand jury material that is very exonerative of President Trump because it needs to be on the record and it needs to be public immediately. Grand jury material is going to come out. They're trying to unseal it, where the grand jury was probably just rigged. They were lied to by Jack Smith because he's illegitimate. And it's going to exonerate Trump. Amazing, of course. We will do that if that's how the government wants to proceed, but for them to selectively portray how they want to proceed with their case shows fundamental unfairness. Defense continues. This has to be done in a very deliberative way, Your Honor. Not back of the envelope. We're saying deal with legal issues first. Your Honor may decide that comms with Vice President were immune, and if so, the indictment needs to be dismissed right away. Let's deal with the gateway issues first. Judge responds, says, well, the Supreme Court had indictment before them with the communications with the VP. They could have ruled on it then, and they didn't. So they sent it back to me, which means I think they want me to deal with it. So not sure I can agree with you that as a matter of law that I can dismiss the superseding indictment at all. Lauro says, of course you can, Your Honor. You should dismiss it right now. It's crystal clear. They're talking about the vice president in the indictment, and that is immune conduct. The Supreme Court just said that. The only issue, Your Honor, is whether they can overcome the presumption, which is an incredibly high bar. And they have, in order to do that, they have to prove that there's no chance at all, no chance of intrusion on that executive branch. It's an incredibly high bar. So if you're in the presumption category, you're basically immune. If they fail, then the whole indictment craters. It goes away. This is logical to deal with these issues. This is how it works. And so they're suggesting that they leapfrog, Your Honor, into merits arguments over all the official acts. Like we're arguing about the official acts when we haven't even decided whether they're immune or not to keep them out of the conversation. All that is wasted time, Your Honor. You're just wasting time if you decide that Pence's communications are immune. And so the judge cuts him off. All right. You've made your argument, which means she knows he's right. Defense says, we need the discovery we've requested. Okay. Also, discovery issues were stayed almost a year ago. We're being put in an incredibly unfair position for no reason at all. And so in light of the SCOTUS ruling, we're talking about a president of the United States. The judge says, I'm not talking about a president of the U.S. You know, it strikes me that you're trying to time the displaying of evidence based on the timing of the election. And I said, I'm not going to take the election into account, right? This has been her position from the very beginning, because she knows it's going to hurt Trump. So it's a nice position to take. Okay, judge says, thank you. All right, Mr. Wyndham, anything back from you? Prosecutor stands up. He says, Your Honor, 5 quick points. All right. 1, about discovery. A big reveal. We have no additional discovery we anticipate. So they should have everything. 2 days ago, we provided grand jury transcripts and exhibits for the superseding indictment, so they have that too. Now, and number 2, we have on the motion to dismiss with respect to the vice president's allegations, SCOTUS was all about a fact-finding analysis and fact determinations. And so it's impossible for this court to make a decision on the vice president until we have facts that are settled. And Chutkan says, well, what about unsealing exculpatory stuff? Wyndham says, well, there are provisions in the protective order that they can follow to litigate that if they want. So we don't agree with them unsealing anything that's going to help Trump if it's exculpatory. Now, SCOTUS doesn't anticipate an automatic dismissal of the indictment number 3, they say. And 4, grand jury struck 9 full pages from the original indictment. Now Wyndham is talking about how, so they say we got 9 pages of stuff out, which is just ridiculous. Can you believe that? They deleted 9 pages of their full indictment. I think it was like 9, there's like 34 pages, like 26, something like that, whatever the numbers are. And it was all stuff that should have never been in there. It just shows you how bad the entire indictment was from the inception. Like if it's so bad, you got to delete 9 pages from it. The whole thing's pretty much bad. Now Wyndham is talking about how the defense filed a 52-page brief in New York just 9 days after the SCOTUS ruling. Says they can work pretty quickly. So they did 52 pages right for SCOTUS. And the judge looks at him and says, congratulations, Mr. Blanche, for writing 52 pages in 9 days. Congratulations, Mr. Branch. And the judge says, look, I don't need any more rhetoric on how grave and important this is. I don't care. Lauro says, it's not rhetoric, Your Honor. It's legal argument. The very first thing Your Honor needs to do is to decide whether that presumption of immunity for Pence's communications can be overcome. Well, why can't I address that in a single brief, says the judge? Why does it have to be piecemeal other than to extend the schedule for your candidate? Your Honor, if you decide this issue, all that briefing never has to take place. We don't have to do that. Just decide it. Why should we engage in months and months of briefing if Your Honor can just decide this issue and it will end the case? They made a calculated risk, Your Honor. They bet that the VP material that they put in this new indictment were going to be held immune. Once that's determined, the case ends. We have an illegitimate prosecutor. We haven't even talked about that, Your Honor. We have an illegitimate indictment. Amazing. Judge says, okay, you want your opening brief to deal solely with the issues about the VP comms? He says, exactly. I'm an originalist. He says, you may be an originalist, the judge, but I'm a trial judge. Thanks, Judge. Yeah, we know. You're sitting up there with your robe on. Great. Now they're discussing the defense request to challenge the propriety of the appointment of Jack Smith. So now the defense is saying, Your Honor, we're also going to challenge Jack. He's not even a real boy. Judge Eileen Cannon said he's fake. They tried to appoint him as a special counsel, but he's not even a U.S. attorney. David Weiss, who Merrick Garland appointed as a special counsel, was a U.S. attorney. Weird. Merrick Garland appointed Robert Hur to investigate the Biden classified documents problem. He was a U.S. attorney too. Weird. How come Merrick Garland couldn't do that same thing with Jack Smith? Why didn't he go get a U.S. attorney to do that? He knows how to do it, but he didn't. Why? Because Jack Smith's a prosecutorial hack. That's why. And now discussing a not a legitimate U.S. attorney. Now discussing this conversation, Trump is going to try to move to have him thrown off this case and this case dismissed as well, just like what happened in Florida. Chutkan wants to know why it wasn't filed when dispositive motions were due. Lauro explains that there was a binding DC precedent against them at the time, but now are very persuasive, right? So the earlier DC circuit, he said we couldn't have won in that one. So now we have to file this now because we got Cannon's ruling. And there's certainly no waiver here. So there's a major change in persuasive precedent. There was a major ruling. And so now we're bringing it up. The judge says, well, this expired well before the appeal in this case. There's binding DC precedent on this. So you have an opinion by a district judge in another court, which frankly, this court doesn't find persuasive. Oh man, Judge Chutkan is throwing shade on Judge Cannon. Ooh, we got a circuit fight going, baby. So Cannon obviously dismissed the classified documents case against Trump, and Chutkan says, I don't even, crap opinion. It wasn't, it was great. Lauro says the court should consider this issue, Your Honor. Justice Thomas, in effect, directed us to do this. He directed you? Well, if you read that opinion, it's something we need to do to preserve that issue. So that's why we're doing it. Prosecutor, he says, Your Honor, despite the binding circuit precedent, Defendants in this court file motions all the time to preserve issues, but they didn't do that. So as long as it does not affect the briefing schedule for immunity, it's hard to see how the government is prejudiced, but don't see any basis for why they should be not found to have waived this issue. The judge says, okay, well, I'm going to allow the defense to file that motion, which she'll deny. Want you to explain why you think you have enough so that binding DC precedent doesn't preclude my granting it. So she's saying, all right, you've got persuasive precedent from another federal court, but I've got a higher court that says I can't do it. So tell me why I should do it. Is it your position that if contacts with the VP are out, the whole indictment is out? Defense. Loro says, yes, Your Honor. They used immune evidence in connection with grand jury indictment. SCOTUS says it has to go. Judge continues. All right, now let's talk about the motion to dismiss based on statutory grounds, now that we have a superseding indictment. Defense says, Your Honor, again, I think immunity should be resolved first before we get to other issues. He says, well, maybe, but we're going to do this concurrently, which is fine. Wyndham, prosecutor, stands up. He agrees all things that can be going on concurrently should. Chutkan now brings up the Fisher ruling, 1512C2, which narrowed the corrupt obstruction, which is the basis of 2 counts against Trump, right? So SCOTUS also gave Trump a major victory on this. The 1512C2 motion, the Fisher case, narrowed it. Basically, it was, you have to destroy actual documents, right? Corrupt obstruction of an official proceeding. It's got to actually be an obstruction of an official proceeding. It's not just going in there and being noisy, which is the basis for 2 counts against Trump. Loro wants to file an entirely new motion, but Chutkan sees it more as a supplemental brief. So, well, you already kind of brought this up, no? Says, I'm inclined to vacate my denial of motion to dismiss based on statutory grounds and simply seek supplemental briefing. So we'll just kind of take a second bite at all this. Loro is now saying that when he talks about discovery issues, he's talking about discovery related to immunity. He's also asking for Brady material, which is any evidence that exonerates the defendant. Judge says, well, yeah, Brady's an ongoing obligation. Do you have any reason to believe that there is Brady material that hasn't been turned over to us yet? There's also a SEPA Classified Info Procedures Act that's also pending, Your Honor. Yes. And the prosecutor says, well, we took a comprehensive review of what should be produced. We've met our obligations. Judge says, I assume the parties are going to continue to meet and confer about discovery. Prosecutor says there are 2 pending discovery motions. There's a motion to compel and a motion to define the scope of the prosecution's team, which, as we talked about, we think is massive. Now, Wyndham, the prosecutor, says, Your Honor, the defense suggested taking up scope of the prosecution team first, but the 2 can't be disentangled. Judge says, I agree. And so now let's set a trial date. She says, actually, setting a trial date doesn't make sense because of the pending immunity issues, which will, of course, go up on appeal. And the judge says, that's enough for today, my friends. Anything else, Mr. Wyndham? No. Mr. Loro? No. Hearing concludes. And of course, please consider listening to Anna Bauer, Ben Witz, and me discuss all this, Roger Parloff, at lawfaremedia.org. And so we're grateful for Roger and his reporting, and we always appreciate his work there inside the courtroom. So make sure you're giving him a follow over on X, and we will repost the top layer thread on this one right on our timeline so that you can go check it out if you're joining us live right at the top and follow Roger along. Now, this is the actual scheduling order that has come out from Judge Chutkan. You can see it's a 2-pager, very quick. Here are the general orders. All pretrial deadlines, except as specifically provided, are hereby stayed. Everything is kind of paused. The original. In the interest of justice, the time beginning from August 2nd to the 24th is going to be excluded under the computation of the Speedy Trial Act, which is normal. The court vacates its denial without prejudice on Trump's original motion, and that motion is now reopened. So it's like you come home, you got to water all the plants again and, turn the AC back up and all the things. So like they're just reopening shop now. Okay, where are we at? So here's the pretrial schedule. It's further ordered that the pretrial schedule shall include the following deadlines. The government shall complete all disclosures by September 10th, very soon. The reply briefs from Trump due by the 19th. We know sentencing is not happening on the 18th anymore. The government shall file this is the big gift to Jack Smith. The government shall file its opening brief on presidential immunity by September 26. So Jack Smith, who's illegitimate, is going to file a big, disgusting motion about all the bad stuff Trump has done on September 26. Not quite October, but it's a little bit of an October surprise. He can't go to trial. He can't actually present any of this. So the judge gave him the next best option. Just write it all down and just file it. Then we'll read it. Trump's response and renewed motion is due October 17th, so he'll defend himself in October. Oh, there's the October surprise right there. So then the government is going to reply. They get the final word since they're going first on October 29th, just days before the election. More disgusting dossiers from the DOJ that will take up a ton of headlines. Okay, it's all going to be new. J6, J6, J6. There'll be a whole J6 series, I'm sure. We're going to go through J6 frenzy, my friends. I can't even begin to tell you how much they're going to try to hit this stuff down our heads. Now, Trump's supplement on the motion to dismiss is due October 3rd. And then the motion to dismiss based on Jack Smith being an illegal, not even a real boy, is due on October 31st. And the reply to Jack Smith's illegitimacy is due after the election. Oh, Judge Chutkan, she's just the worst. So she signs that off. You see exactly what she's doing. All right. Couple October surprises. The timing is perfect. So you just go, Jack, write every bad thing you've ever thought about Donald Trump, and we're going to release them. One in September and one in October. Great. So very, very, very interesting update over from Judge Chutkan. The government is going to be having an opportunity to create a nasty Trump book report. They'll time it and drop it in months that most impact the election. And then they'll allow Trump to file responses, at least to Jack Smith's illegitimate boy issue after the election. That's from Judge Chutkan. Not interested in the election at all, she says. Doesn't care about it. No, it's not even in her mind. Okay, Judge, then why do you schedule stuff like this? To cause maximum damage to the defense and to give the government the first crack at all of this. You could have just settled this case with a decision on the VP, but they're not going to do that because it's not about justice. It's about political prosecutions of their opponent. And we're going to be here to continue to cover it and to call it out. And so thank you, my friends, for subscribing to our channel. Wherever it is you're watching this, we'd love to see you back here when we go live again. And we'd love to see it if you brought a friend or family member over so that they could join us on this journey. And we'll see you and them back here on the next one. All right, my friends. Now, we're not done yet. We've got one final segment on the day, and then we're going to hear from you. And this was a good one because we're on an appeal now. Donald Trump attended his appeal of the E. Jean Carroll case, oral arguments taking place in the Second Circuit. We're going to go through and listen to the full hearing, about 10 minutes each side. Trump also came out and responded, explained a lot about what he thinks about E. Jean Carroll here, maybe a little bit nervous because he's already been sued for defamation and other things. But Trump, I think, knows what he's doing here, and we're going to break down what he says. But this is the page where the oral arguments occur. You can see the case is 23-793, Carroll versus Trump. Oral arguments took place September 6, 2024. And if you remember, E. Jean Carroll was the woman who says that she got Bergdorfed in a dressing room at Bergdorf's. And the jury came back out and said, no, actually, you did not get Bergdorfed in there. They gave her liability, Trump liability on the second count, which was for grabbing him by the purse type of situation, but it was not the old in and out with, the items. It was something the jury found she was not credible on. We call her a liar. So while they come out and say that Trump assaulted or raped a woman, we say that she's a liar. And you can see there were oral arguments that took place here. We're in the Second Circuit. Let's listen to these oral arguments together and unpack what happened today. Trump was in attendance. Here is how the day started.
Carroll versus Trump, that is 23-793. Mr. Sauer, is that correct?
Yes, Your Honor.
Am I correct that you have reserved 2 minutes for rebuttal?
Correct, Your Honor.
Okay, when you are ready, you may proceed.
Thank you, Your Honor, and may it please the court. John Sauer appearing on behalf of the appellant, President Donald Trump. This case is a textbook example of implausible allegations being propped up by highly inflammatory, inadmissible propensity evidence. As President Trump testified, he never even met Miss Carroll and didn't know who she was until the allegations were made. There is no physical evidence, no eyewitnesses, no DNA, no video, no complaint, no police report, no investigation. A quintessential he said, she said case that involves a plaintiff who, with a political motive to bring a story, who's funded and encouraged by President Trump's political enemies, raising decades-old, 40-year-old allegations, or decades-old allegations.
Your arguments are evidentiary issues, and as you know, we give great deference to the district courts on these matters. It's very hard to overturn a jury verdict based on evidentiary rulings. We use phrases like manifestly erroneous. So why should we order a new trial here?
Your Honor, I think for two reasons. It's very clear that there was error in the admission of the propensity evidence, so the Leeds testimony, the Stoynoff testimony, the Access Hollywood tape. As we pointed out in a brief, none of those are even remotely admissible under Rule 413 and Rule 415, which is the principal reason. And then as to the 404B argument they've kind of pivoted to after the trial, they argue that it was evidence of modus operandi. And of course, modus operandi evidence has to be used to show a proper non-propensity purpose, which they've never identified. So identity is not an issue here. Absence of mistake or accident, not an issue here. You have a situation. Sorry, Your Honor, go ahead.
You do agree, though, that Congress has passed Rule 413, 414, 415 to allow propensity evidence that would be excluded in other kinds of cases, but to permit its consideration by a jury in certain cases here?
Only if it meets the criteria.
So propensity evidence is evidence that it is tending to show someone acted in conformity with their prior behavior. So if you get a DUI, right, you get a DUI, you get a DUI, you get a DUI again, and you get pulled over and a cop looks that up, he's going to say, I'm wondering if you have a DUI again, right? A cop is thinking this guy has a propensity to drink and drive. And so there may be propensity that he's drunk again, right? And you can do that in criminal cases. And they try to do this a lot in like sexual assault cases. They'll say a woman comes in and says she was attacked, and it's a he said, she said situation, but then they look back and they say, well, this woman's claim and this woman's claim and this woman's claim. And so they'll aggregate them together to make their case kind of stronger and bring them all as separate victims, right? It's the propensity to do the thing.
Criteria set forth in this case 413D 1 through 5. So take, for example, the Leeds testimony. That's the sort of 1979 story about the airplane. And again, it never happened, but assume that that the jury were to accept the argument. It has to meet those criteria. 413, for example, it has to be a crime under state or federal law. They never even identified any statute that this conduct alleged supposedly violated, except for 49 USC 46506, a statute that was enacted 15 years after the allegation in place.
What about Federal Rule of Evidence D5 and 2? 5 being an attempt, 2 being contact without consent between any part of the defendant's body and another person's genitals. If the defendant, assuming it's true, put his hands up her skirt, why doesn't that qualify?
That would, I think, the case law
Why
here.
would that be an attempt to engage in that conduct?
The case law, I think, on attempt is very strong for us, and I think decisively rejects that. I point to the Hayward case from this court, the Rogers against State case from the Florida Supreme Court, and other cases. For example, if you look at the facts of the Hayward case, they're facts that are just egregiously beyond it.
Look at this case. Is it manifestly erroneous for Judge Kaplan to say, yeah, this is at a minimum arguable and we'll let the jury decide?
Well, as we argue in our brief, the proper standard of review when it comes to a legal error on the interpretation of Rule 413 is de novo, but it's erroneous under any standard of review. Because if you compare it, for example, to the egregious facts of the Hayward case and the Rogers case, even what was alleged, which I emphasize never happened, even if it was alleged, it would be anywhere close to fact patterns that this court has rejected as attempts, and also the Florida court as well. Yes, Your Honor.
I just want to take a step back. My understanding from both of the papers is that our court has not yet ruled on what is a standard of admissibility for under Rule 415. Both of you cite to Third Circuit law. Is that correct?
That's my recollection of their brief.
In your view, that this is a question of first impression for us?
on the standard of admissibility for Rule 413. It depends on which of the issues we've raised. Some of them are addressed in other circuits and some are not. By and large, the arguments I've been addressing now are questions of first impression for the Second Circuit.
Okay, so when you're trying to get evidence of someone's propensity to do a thing, you stole the candy bar. I know you stole the candy bar this time because I know you stole the candy bar 3 other times. Like you got 3 convictions for stealing a candy bar. You got caught with a candy bar in your pocket. And now we're just going to presume because you have the 3 other candy bar convictions that now you're guilty of a candy bar again. So how do you get the evidence of the 3 first candy bar, or maybe not even convictions, but candy bar incidents into evidence? That's what they're talking about. And they're saying it's kind of a matter of first impression here. And the lower level judge, Judge Kaplan, during the trial just admitted a ton of stuff in that should have never come in.
However, we point to case law from other circuits that's very...
Is there anything about the Third Circuit's understanding of what this admission standard is that you would have us depart from?
Not that I can think of, but there are multiple Third Circuit cases. I want to be careful how I answer that because there are multiple Third Circuit cases cited in the briefing. There may be things in some of them that we disagree with. Overall, the standard of admissibility is what's set forth in the plain text of 413.
I just want to make sure the standard that you believe that we should be dealing with is a reasonable jury could find by a preponderance of the evidence. Is that correct?
Yes, we have not disputed that in our brief. That's correct.
And that is the one that you believe that we need to adopt in order to move forward?
I would say we have not disputed that in this case, is the way I'd frame it. And again, that standard, however, in this situation, we're dealing with interpretive questions as the meaning of phrases in 413, D1 and D5 and D2. Those, for example, are pure questions of law that are subject to de novo review. That's not a situation where a reasonable jury can determine whether or not something legally constitutes an attempt, for example. So,
Okay, and de novo review is basically a fresh set of eyes. You don't get to take what the lower court did and then only overturn it if there's a higher level of error, manifest injustice or something like that. It's actually a de novo review. So then you look at it with a fresh set of eyes and say, oh, that should have never come in as evidence. So the jury should have never considered that.
As one example. Take another example. If you look at the Stoynoff, if you look at the Leeds testimony.
Sawyer, you're speaking so fast.
Yeah.
I apologize, Your
Slow
Honor.
down a touch.
It's an important case and I'm passionate about it.
Got 10 minutes.
The Leeds testimony,
You got 10 minutes. You give me some more time? I got a lot to say. I got 10 minutes, dude.
for example.
Slow down.
We've argued that the Leeds testimony was inadmissible.
Just listen faster. God.
Under, for example, D1. D1 says conduct prohibited by Chapter 109A. Every federal statute in conduct, Chapter 109A has a federal jurisdiction requirement. That's an element of the offense that says within the territorial and maritime jurisdiction of the United States or similar language.
What do you make of other statutes where the phrase conduct prohibited by is used as distinct from jurisdictional requirements? For example, 18 U.S.C. 2332 GB also has the conduct prohibited, but they also have a jurisdictional statement. Like, how are we supposed to take your argument in this matter? Like, isn't this also an area of first impression for us that we have to decide whether or not the jurisdictional elements are incorporated?
And it is one that where there's clear guidance from the U.S. Supreme Court, for example, in the Omni Capital decision that we cited, as well as the Hart versus Reliance Insurance cases, where the Supreme Court says, look, when Congress knows how to specify something, then the fact that it didn't do so raises the inference that that's not what they intended. And we cited, at least as Your Honor points out, 6 federal statutes.
Doesn't that presume the acceptance that conduct also incorporates a jurisdictional requirement? They use the words prohibited conduct as opposed to an offense or some other interpretation. So if you could just hone in on that particular component of it.
Yeah, and we point out the plain meaning of prohibited is to forbid by authority of command. In Chapter 109A, Congress has not prohibited conduct that doesn't occur in certain federal enclaves, essentially.
These statutes were intended to allow, contrary to common law, evidence of regarding conduct that was serious, of a serious nature. And I'm not sure how the jurisdictional element, the precise jurisdictional element, whether in an airplane, in the specific maritime jurisdiction or what have you.
Yeah, and I should say that propensity evidence is disfavored, right? Because you want to be able to prove the person who stole the candy bar on that date. You don't want to just say that we think you stole the candy bar because you did it on prior dates. Okay, do you have the evidence for this one? If you do, present it and let's see it. Otherwise, that evidence should not come in because it's propensity evidence. It's not actual evidence that shows you that somebody did the thing at that date, time, and location.
Impacts the conduct that Congress was willing to let juries consider in adjudicating these kinds of cases. Could you address that concern?
Sure, I'd say two things in response to that. First of all, Congress' intent is best reflected in the plain language of the rule that it enacted. That rule says it has to be conduct prohibited by 109A, and there really isn't a good argument that that means conduct that, if it had been performed in special maritime and territorial jurisdiction, would be prohibited, which is what they argue it means. And one powerful evidence of that is there are 6 federal statutes where Congress said exactly that. They said conduct that, Your Honor, I see my time has expired. May I finish answering the question?
You may finish, but then we'll move on.
Okay. And so there are 6 federal statutes where they said exactly that, conduct that, if it had happened in these federal enclaves, would be prohibited. Here they did not say that, and the compelling inference is it's not what they intended.
Okay, thank
Thank
you
you,
so much.
Your
We'll
Honor.
hear from you on rebuttal. We appreciate it.
All right, so that's John Lauro, Trump's defense.
If you don't mind, Ms. Kaplan, starting from the jurisdictional issue?
Yes, for sure. I'm going to move this down, I'm
You
sorry.
should. We wouldn't be able to hear you otherwise. Thank you.
Yes, let me,
Government
Roberta
prosecutor.
Kaplan for plaintiff E. Jean Carroll, appellee, may it please the court.
no, this is Roberta
I don't
Kaplan?
believe Your Honor does have to decide the jurisdictional
Not a-
issue.
not a
You could decide
prosecutor.
it here, Judge
Civil
Perez,
case.
but you don't need to. And the reason is because there's a federal crime now, independently of what Mr. Sauer talked about, that prohibits sexual contact in the special aircraft jurisdiction of the United States. I'm sorry, Your Honors, I've become an expert on aircraft jurisdiction now. And even with respect to Mr. Sauer's argument, which he raised for the first time on reply, that there wasn't a statute in 1979, there was a statute in 1979. It prohibited assault on a plane. And what Ms. Leeds testified that Mr. Trump did on that plane was clearly an assault. So
Oh
you
my
can
gosh.
decide the jurisdictional point, but I don't think you need to for those reasons.
Okay, so
Your
Trump
Honors,
assaulted someone
taking
else
it back a little.
allegedly on an airplane, and they can talk about that other unsubstantiated claim as evidence in trial as propensity evidence. The whole thing.
Little bit. Despite the prominence of this case and the parties involved, it really just involves the routine application of the federal rules of evidence. That application was performed by Judge Kaplan, who has many years of experience trying cases, and just so the record is clear, who is neither related to me nor is my mentor. E. Jean Carroll brought this case because Donald Trump sexually assaulted her in 1996 in a dressing room at Bergdorf Goodman.
No.
And then defamed her in 2022 by claiming that she was crazy and made the whole thing up.
She is
After
crazy.
a nearly 2-week trial,
And she
the
did
court,
make it up.
the jury found in Ms. Carroll's favor. At trial, we called 11 witnesses. They included Ms. Carroll, who testified for
They found that she lied about being raped in the dressing room.
nearly 3 days straight, most of which was cross-examination. And here's what she said. Question: when you're fighting and being sexually assaulted and raped, because you are not a screamer, as you describe it, you wouldn't scream.
I'm sorry, I just want to make sure that we're going back to the evidentiary issue.
Yeah, what is
So
she talking about?
I count that we have been asked to consider 3 questions of first impression. One of them was one thing that you mentioned a moment ago about whether or not 415D must have been a crime at the time that the crime was committed. Is that correct? And then the jurisdictional question about whether or not the requirements of 109A have been incorporated by D1. Your opposing counsel cites a judicial council recommendation, which Congress did not adopt, that would have added clarifying language to Chapter 109 to have made it crystal clear that the jurisdictional component was separate from the conduct component. What do you make of that?
I make, Your Honors, as we always do with legislative history, is that Congress rejected that. And the Violence Against Women's Act, which is these evidentiary rules grew out of, are one of the few evidentiary rules that were actually passed by Congress. This didn't come from a rules committee. This came from Bob Dole and Susan Molinari of Staten Island. And it was part of the Violence Against Women Act. So to me, that obviously only cuts our ways. And let me just be clear about what Judge Kaplan held here, because I think its clarification would be helpful. As Judge Kaplan held, Trump's conduct is a federal crime because it violates 49 U.S.C. 46506. If you go to 460506,
Wasn't charged.
Before I get there, under 43D2, it was an attempt, it was a sexual contact and an attempt as sexual conduct. Section 46506.
No evidence.
Makes it a crime to do certain things on an aircraft, and here's my favorite phrase, in the special aircraft jurisdiction, that if committed in the maritime and territorial jurisdiction of the United States would violate provisions of 18 U.S.C. In other words, Section 46506 takes certain parts of the U.S. Code and says they're a crime on an airplane. As Judge Kaplan found, Section 46506 cross-references 18 U.S.C. 2244A1, which covers knowingly using force to cause or attempt to cause another person to engage in sexual contact. Sexual contact is defined as touching directly or through clothing.
You see what they have to do to get this to work? They have to go make up some other thing that happened some other place on an airplane, find some weird statute, some weird thing to connect all the dots, right? She's like walking us down, like following the bouncing ball all the way till we get over here. If there was enough evidence that Trump did the thing, we would just have the evidence that Trump did the thing. We don't need to come up with all this convoluted nonsense in order to find some airplane thing to talk about another incident, to bring that incident in as propensity evidence that then is used to make Trump guilty. It's totally rigged.
The breast or inner thigh of any person or intent to do the same. What you hear from Mr. Sauer is that doesn't count because in 1979, that wasn't a crime. And that's the argument they first raised on reply. But the answer to that is it was a crime in 1979, and this is a new statute without our brief because we didn't have a chance to respond to it. In 1979, the predecessor was 49 App USC section 1472K, and under that section, it was a crime to commit a simple assault on a plane. And there are multiple cases, including the Bays case.
Sorry, I thought your opponent said that the predecessor crime was actually rape.
That's what
You
he
believe
said.
that's incorrect.
That's incorrect. The predecessor
Say
crime
simple assault.
is a simple assault on a plane, and in the Bays case in 2000, the First Circuit held that that simple assault includes a guy who was on a plane and, excuse my, smacked the stewardess's tush as she was coming up the aisle.
Assuming there is jurisdiction here, back to the facts of the Leeds case, why isn't it very different, substantially different? It occurred on an airplane, which makes it very different from the other incidents.
Look, I think let me put it this way. The fact that this was on a plane, Judge Chen, has inserted all kinds of complexity in this case. It's actually not that complex. It was a crime then to grope someone on a plane. It is a crime today to grope someone on a plane. And as I said, I was thinking this morning, this may be a situation where you have too many lawyers trying to screw in a light bulb.
Gosh.
You don't have to get to, it clearly was a crime.
No, I'm assuming for these purposes it's a crime, but the fact pattern is different from the other incidents, which were in much more private places.
So
does that make it too different to be relevant?
I
mean,
would-
the probative value becomes less.
So I would concede that unlike Ms. Stoynoff, Mr. Trump did not lead Ms. Leeds into a private part of the plane. That's for sure true. But the rest of the pattern is exactly the same. He had a pattern of having kind of pleasant chatting with a woman, kind of, Eugene Carroll even testified that it was almost flirtation, very pleasant chatting. And then all of a sudden, out of nowhere, he would, for lack of a better term, Your Honors, pounce. And that's exactly what happened with Leeds on this plane.
Yes.
He didn't let her out of it when she tried to squirm out. She ultimately succeeded. And then, to finalize the pattern, once these three brave women came forward and said what had happened to them, he said the same thing about all three of them.
So what if we just say that you're wrong on this, that it's too remote, it's too unlike the circumstances that your client alleged? What assurance can we have that it didn't unduly affect the jury's verdict?
So, if you're talking about Jessica Leeds.
Yes.
So, you obviously
the
look,
airport, the remoteness in time,
right.
the difference in
You look at it,
circumstances.
as I said before, in a manifest injustice standard. And I was going through the evidence at trial. It was incredibly powerful. Not only did you have Eugene Carroll, you had two outcry witnesses who she told immediately after the assault.
Oh, gosh.
Who both testified.
They
One of
didn't
whom was
even
in this
like
courtroom
Eugene
today.
Carroll.
You had
They just
two
hate Trump.
people who were former employees of Bergdorf Goodman who did not know Eugene Carroll, but who corroborated fundamental facts about the operations and the layout of Bergdorf Goodman back in 1996. You had a psychological expert, who's an expert on trauma,
1996.
Dr. Lebowitz, who at Mr. Trump's counsel's question was able to say that she believed Ms. Carroll and that Ms. Carroll wasn't malingering. She also
So,
described.
I'm sorry, so I just want to, I'm sorry, go ahead.
But the witness you're describing is someone who heard a report as opposed to was a witness of some kind. But please go ahead, Judge.
No, I was just going to ask, so is it your position, and it sounds like what I'm hearing you, is that you could lose all of the propensity evidence and you still would think it would be harmless error? Like, are all of the questions that we're
I
talking about?
believe I could lose
harmless?
all the propensity evidence and still be harmless error, except that the Access Hollywood tape, as Judge Kaplan noted in his post-trial motions, is better admitted as a confession. Party statement, he said, this is what I did.
Okay, so even if the judge, she's saying, even if the Judge Kaplan at the lower level district court admitted all that bad propensity evidence against the law, right? So all of those other candy bar theft examples, oh, you did it then, the airplane, this woman, this woman, this woman, this candy bar, even if all of that came into evidence, it was just harmless error. It was not overly prejudicial against the jurors. The jurors just heard that and said, well, I don't really care about any of that, and so we're just going to convict him anyways, right? It was not overly prejudicial against Trump. That's her
Women
position.
by the pussy without their consent. It was after what he did to E.J. and Carroll, and we cite the case in our brief where a guy says, I'm a drug guy.
Well, wait a minute, is
And
the
that was
harmless
enough.
error standard harder for you because of the clear and convincing burden of proof on the defamation claim?
No, because this is all about the assault, Your Honors. In order to prove defamation, we talk about in rejecting the categorical approach under 415, as Judge Kaplan, as Judge Furman, and as every other circuit has decided it has said, there's an overlapping factual element, but it doesn't mean once the actual element is found, as it was found here on the battery claim, it doesn't mean it changes the evidentiary standard, and it wouldn't convert it into non-harmless error. If I answered your question. You're looking at me like I may not have.
I'm thinking.
On top of all that, you had Donald Trump's own testimony. Now, Mr. Trump is here today. He was given every opportunity by Judge Kaplan to show up at this trial, and he was even given till 5:00 p.m. on the Sunday before closings, and he didn't show. He had every opportunity to just take the stand and rebut all this evidence. He did not. He did not
Why
put
would
on
he
a
do that?
single witness.
It's the right to
In
remain
a civil
silent.
case,
I
we
know
put
it's a
on
civil
11.
case, but
what
it's a
we
right
did
to remain
put in
silent.
Is this videotape of Access Hollywood where he basically says, I grab women by the pussy, excuse my language, without their consent. And then at his deposition that I took and asked him about that video, what did he say? He embraced it, Your Honor.
Thank you for your time. We appreciate it.
Thank you for your time. You're done. All right, rebuttal from Trump's attorney. This is an appeal in the Second Circuit Court of Appeals. This is the Trump
Thank you,
appeal
Your Honor.
on
Just to
E.J.
turn to
Carroll.
that harmless error point, the standard for harmless error is the court has to have a fair assurance or a conviction that it did not influence the jury, and that argument really can't be made with a straight face here. I would point the court to...
Why is that? I mean, I noted a conspicuous absence of reference in your briefs to the so-called outcry witnesses, to Ms. Bernbach and the other woman who had been spoken to at the roughly contemporaneously. So why isn't that enough? That confirmatory evidence that's contemporaneous with the event.
Yeah, I'd say two things that sort of make that not a strong argument for them. One is the outcry witnesses had egregious bias against the defendant. Their prior social media posts and text messages said things totally unrelated to this
Hated
case
Trump.
based on his
Didn't even
politics,
like
said
EJ.
that he's herpes we can't get rid of. He's compared
But
to
you had an
Putin's
opportunity
stooge.
to cross-examine them in front of the jury, right?
Yes, but the question in harmless error is what harmless error is not, could the jury believe it, but was the jury's judgment about that tainted by the fact that they also heard all this inflammatory evidence? And one thing that this court and other courts emphasize is how did the plaintiffs use it in their opening statement and their summation? And here they relentlessly hammered the propensity evidence, the Access Hollywood tape, the Leeds testimony, the Stornoff testimony. If you look at the summation,
I
it's
looked at the opening sentence, at the opening statement and the summation, and I didn't see the relentless hammering that you're describing. I saw mention of it, but also emphasis on the outcry witnesses.
there is discussion of the outcry witnesses, but for example, look at the summation. The first 4 pages of the summation go through Access Hollywood, Leeds, and Stornoff before they ever even get to Carroll's own story. And then if you go to the end, they emphasize it again, and it's emphasized again and again.
How do you respond to the argument that the Access Hollywood evidence is different from the propensity evidence? It's not propensity evidence. It's really a confession.
They've argued it's propensity evidence in their brief. They say it's propensity, and it's hard for me to...
What about the argument, whether it's new or not, that it's not propensity evidence, but it's a confession. How do you respond to that?
It's hard to see how it's a confession because that's the underlying problem with it, is that they don't point to any specific incident that it's a confession of. And so for them to speculate
Well,
or
it's a confession about a modus operandi.
but modus operandi itself is inadmissible, and a confession to a modus operandi to be admitted and not be sort of so prejudicial and inflammatory, which is what it was and how it was used, is just not something that is admissible. It involves speculation and conjecture to assume that it relates to any specific incident when they
Nicely
never
done.
identified one.
John
I see
Sauer.
my time has expired.
Thank you so much. We appreciate it.
All right, so that is it. That's the brief oral arguments that took place. This is the E. Jean Carroll case, the grab him by the Bergdorf case that Trump was found liable on. It's a civil case brought by Roberta Kaplan and E. Jean Carroll, all connected by George Conway, bunch of rabid anti-Trumpers who brought this claim. And Roberta stands to make a ton of money on it, I would imagine, if she is getting a contingency fee off of the E. Jean Carroll verdict. But Trump was there, as you heard, in court today, listening to those oral arguments. He had something to say about it in the aftermath. Here is the president.
Two witnesses. One is a woman who's followed me for years. She said in 1979, I was in an airplane with her, commercial flight, and we became very intimate. I just sat down. I think I had the book, The Art of the Deal. I was famous then, too. I've been famous for a long time. And we're sitting in first class, according to her. Never happened, by the way. Totally made up story. She's a Clinton person, too, by the way. Big Clinton person. She made up the story. And so many years ago, and I think it would be 1979. One of my many people behind me could correct it, but I think she said 1979. That's a long time ago. And I sat down. I believe I had some pretty big success then, and I was being talked about a lot. Maybe The Art of the Deal was out, sometime after that. I'm not sure. But I was well known. And passengers are coming into the plane. And she said I was making out with her. And then, after 15 minutes, and then she changed her story a couple of times. Maybe it was quicker. That I grabbed her at a certain part, and that was when she had enough. Now, so think of the impracticality of this. I'm famous. I'm in a plane. People are coming into the plane. And I'm looking at a woman, and I grab her, and I start kissing her and making out with her. What are the chances of that happening? What are the chances? And frankly, I know you're going to say it's a terrible thing to say, but it couldn't have happened. It didn't happen. And she would not have been the chosen one. She would not have been the chosen one. She has gone around for years saying the story. Everywhere I go, she says this story. And it's a total lie. Now, I assume she'll sue me now for defamation, like I got sued by E. Jean Carroll.
E. Jean Carroll got sued for defamation. So I think he was not talking about E. Jean there. I thought he was talking about E. Jean. He's talking about some other woman on an airplane that was used as propensity evidence in those oral arguments that we just heard. And so the appeal marches forward. We'll be here covering the decision when it comes down. Not optimistic about this one. I think Trump will have to, more likely than not, take it from the Second Circuit up to the Supreme Court and get a final decision from them on this propensity stuff. The three judges that were on the panel today, Obama judge, Biden judge, Clinton judge. So we understand where this is going to go, and Trump will continue to fight on, and I think he'll be vindicated in the end. And so thank you for joining us on this one, my friends. Thank you so much for subscribing wherever it is you're watching this. Thanks for liking this video and for leaving a comment. We'd love to hear from you, and we'll see you back here on the next one. All right, my friends, we covered some good ground today. If you're just joining us, the big news on the day is that Trump's sentencing has been postponed. And so rewind this video if you just are joining us, because that sentencing date just got moved to November 26, 2024. So the sentencing on the September 18th date, not happening. After the election, if necessary. And so that is what we talked about. We read through the whole filing, and it was a good one. We also talked about what happened in the January 6th case, We know that Jack Smith got a big fat gift handed to him in the form of the permission to file a book report. And then, of course, we listened to the oral arguments for E. Jean Carroll, and we learned what's happening in the Second Circuit. But now, my friends, it's time to hear from you. Thank you so much for joining us on this Friday early show. Your boy's about to wrap up and head to the airport to head back to Phoenix. And so it's been a lot of fun hanging out with you today. Let's see what you have to say about all this before we pack up the gear and hit the road. What's up, Tara? Tara Rayner's in the house. Says, next time, pick me. LOL, I would love to see all these great thinkers. It was the trip of a lifetime. It was really, really a ton of fun. Thank you, Tara. Next time for sure. What's up? Tara says, I live in Innisfell, Ontario, Canada, and there was a large Trump 2024 sign near my place. Giggle like a kid every time I see it. The tide is turning for Canada. Shout out to our Canadian friends, our friends up in Ontario, Canada. What's up, Tara? Thanks for the membo. Thanks for saying that. And for the dono. What's up? David Webb became a new YouTube membo. Good to see you, David Webb. We had a members only stream yesterday. So for our new membos, check out the members only stream that we had yesterday. Then we had to hit the road. What's up? Philip B says, Philip Butler's here, says he knows jailing Trump will cook Kamala's goose. Yeah, I think that's true. I think that's true too. He does not want to sentence him because if he doesn't sentence him to jail, then I think the left will be upset about it and Trump will have escaped again and Trump will appeal it. And if he does sentence him to jail, it's the end of the country probably. Thank you, Philip. Hey, what's up? Dear Emily says, hey, Rob, I have info on Fanny's daughter that I need to get to you. Is there any way to send it to you directly? Thanks for all you do. Yeah, dear Emily, that sounds like a good one. Fanny's daughter, Kinaya, and her multiple traffic infractions. My email is robert@spotlightlawyer.com. And I check it, and I'm getting better about responding to emails, especially the newer ones. I'm still working through my backlog a little bit. But yes, I'll take a look at it. Thank you, dear Emily. Sounds like a really good one. robert@spotlightlawyer.com is where you can reach me. And I do read the emails. What's up? And thank you. Thank you, dear Emily, for the research and the dono. We got this one from Darren McNeil. Hey, a new YouTube membo. Good to see you, Darren. Check out the members only stream from yesterday. We have this one from Just Rhonda. 10 new membos coming in the community. Thank you, Just Rhonda. Welcome aboard, 10 new friends, courtesy of Just Rhonda. We got more membos. What's up? Kay Hawkins got a membo. Welcome aboard, Kay. Thanks for becoming a membo and supporting our work here. We do Saturday streams for membos also. So tomorrow we'll have a Saturday stream for membos. So see you over there. Rick Donner, what's up, Rick? 5 membos coming in courtesy of Rick Donner. 5 new friends. You know who you are. Welcome aboard. Courtesy of Rick D in the house. What's up, Tony Hay Munkets? 10 membos courtesy of Tony Hay Munkets. You rock. What's up, Tony Hay? Thanks for bringing in the 10 membos, brother. Hope you're having a great Friday. We got Patriot Rob says, they're going to do something stupid and find them guilty of January 6th on January 6th. It's going to be stupid. Yeah, and they'll wear like January 6th glasses. The prosecutors will. I'm like, yeah, I can see it. It's all they live for because they have no real meaning, purpose, or life. It's just insurrection all the time. What's up, Colette? Colette Dunn says Carroll was never raped. She remembers nothing. Yeah, I think she's just an unwell person who just made up a story that was exploited. She was talking to George Conway about it. He's like, wait, what? Oh, we can use this. And they just concocted a hack job, all the jobs against Trump. So thank you for those great donos, Colette, Patriot Rob. Thanks for the membos who just came in. We've got some donos over on locals we'll say hello to. And then we're going to go over to locals for a members only after party to wrap things up before we hit the road today. Hey, Sweet Potato. Oh, sweet. You're so sweet. Hey, check this out, my friends. Sweet Potato is a great membo over on locals. And Sweet's been around for a long time. We love Sweet Potato. And we're praying for her father and her family right now. But Sweet says, happy birthday. Seems like each year is only getting better. I agree with that. I absolutely agree with that. Every year is just better and better every year. Wishing you another year of great health and happiness. Thank you, Sweet. Such a sweet thing. It's been a heck of a birthday. I mean, the way that this whole trip unfolded and everything, it's been like, what? So thank you, Sweet. Yeah, it's been beautiful. Thanks for saying that. Chubby, what's up? Says, I have to wonder if Mercan's delay is related to the House investigation. I think it's just he doesn't want to sentence him. Yeah, I think he just doesn't want to sentence him. He knows it's too much to bite off. E. Harris says the DOJ chief of public affairs admits that Trump indictments are a politically motivated perversion of justice. Says Alvin Bragg was just stacking charges just to make it fit a case. I think the case is nonsense. It's a perversion of justice. It's a travesty of justice. Interesting. I have not seen that clip yet, but it sounds like it's a great one. Chubby says, did they include corkboard with tacks and red yarn to try and show their crazy logic paths? Yeah, like that guy in that, all the mugshots on the back of the corkboard. This is ludicrous. Wish they'd try harder to keep Kaplan on point though. Yeah, she was just like re-talking about the case. She's like, let me tell you what happened in the case. They're like, we know. Tasadaka says, they keep bringing up the Access Hollywood tape. They misquote what is said in the tape every time. Trump said that some women will go after a man who has money or fame and they will let him grab them. He never said he did that. I think he said like you can just grab them by I don't remember what he said explicitly, but yeah, it's propensity evidence that they're trying to use to harm him because they have no actual evidence from E. Jean Carroll. So they have to go back out, find a bunch of other evidence. Hey, Zulu's in the house. What's up, Zulu? Modding down the fort for us. Also helps with new membos coming in. Thank you, Zulu, for bringing in 10 new membos, 10 new friends. Welcome aboard, courtesy of Zulu. We got Judge Mental in the house. What's up, Judge Mental? Says, hey, Rob, long time no see. UK been having problems. Yeah, UK is a little bit problematic right now, no doubt about it. We've been seeing people get arrested for really weird things, like stating their opinion on the internet. Is that what's going on in England now? I can understand that. Thanks for being a member for 3 months, Judge. We got this one from Jay Water. Road Less Wolf says, is there a law that specifically says that prosecutors must be employed by state or federal appointed to bring crimes against individuals? No, I don't. I mean, I'm sure there are laws, but I don't know which one like you're referencing or what you're asking about specifically. But the prosecutors get their power from the law and they swear an oath and all those things. So there's a process they go through in order to get the power to just indict people. What's up? T-Dog says, T-Dog in the house says, happy birthday, brother. Thank you for that, T-Dog. 1 month as a membo. Keep up the great work. Thanks for saying that, T-Dog. It's been a heck of a birthday. And I'm excited about what we were able to do here to celebrate, even though we're not celebrating. It just feels like it's my own little personal celebration, but that's how I like it. All right. So my friends, thanks for sending in all of those incredible donos. We are going to wrap it up right now and head on over to Locals, watchingthewatchers.locals.com. If you want to join us, we'd love to see you over there. But if not, we are going to be back for Membos tomorrow. Maybe we'll see what tomorrow is, but we'll be back tomorrow because we'll be back in town. But we are going to leave it there on this week. It has been a heck of a week together. I am very grateful that we got to go through these cases today. I think they're very important updates on all these matters. Thanks for joining us. Thanks for being a part of the Watcher fam here. And I want to wish you the best weekend you can possibly have. Hopefully, you can do something fun, do something exciting, do something interesting, rest, rejuvenate, restore. Because we're going to come back here on Monday and we're going to get into it all again. And in order to do that, we're going to need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. Rumble, I had one dono that I saw from my Rumble friend. Sorry about that if I missed anybody. But Rivka the Jade Gamer, had a dono. Says, now that I'm not driving, why wasn't Trump's attorney arguing that any process that could be negated by immunity is a violation of immunity? Chutkan already conceded that point. I think he did make that point. That immunity is meaningless if you have all of the things happen, all of the conversation happen, right? Immunity prevents you from having to go through all of that stuff. So I think they were kind of talking about it in a different way. But thank you for that, Rivka. Thank you to our Rumble friends. That is going to be it for us on the night, my friends. So get out there, get after it. Make it a great day, and I'll see you back here soon. Bye-bye.